Hello everyone, and once again welcome to the YouTube channel of Get Set Law by IMS. My name is Siddhant Singh, and guys, as you can see it on the screen, that this particular video, this session is for the students who are preparing for law entrances that is going to take place in the month of December, in the next span of 6 months. So we are coming up with this new concept that we will be taking up the monthly current legal matters over there with you. So as you can see over here is for the May month. Now you might be wondering, ki, sir, what about January till April? Don't worry, there will be a separate video where we are going to provide it in the playlist. So go and check it out in our playlist. It will be there. So don't worry about it. Okay. So how this particular session is going to work, I'll just give you brief out of it. But before I would continue this video, I would want all the students to keep ready with their pen and proper copy, book, everything, so that I would want all of you to note down the topics, and I have properly placed it in a manner so that it will help you in making the topics relatable. Now the importance of current legal affairs, why we need to read it. So you are already reading newspapers, there are already monthly magazines or the magazines which are already with you there. Okay, so these concepts, or maybe there are sessions which might be taken up by your own institute, maybe weekly, monthly, half quarterly, whatever it happens, but these majorly come in a form of a paragraph. So you are not at all required to learn these concepts, and you are not even required to remember or revise all these judgments, that what was given in what judgment. Rather than these videos, if you only watch the video properly for the next half an hour to 1 hour till the time length of the video is, then also these topics will going to become relatable for you. So we study all these topics so that in the paragraph, whenever a new passage comes, which I don't study in my on static legal topics like contracts, constitution and criminal law, etc. Besides that, these topics become relatable. Okay.
To book a free one-on-one law counseling online or at any IMS center, check out the link in the description box or the pinned comment below.
So I've taken up 10 most judgments which has happened in the month of May, that is there on the screen. I'm going to take up in a form of that what actually happened in the case, with every case individually, then what was the question which was under debate, what was the final verdict, and then what is the legal concept which you can revise, read more about onto it. Okay, but you don't have to learn anything, it's a big disclaimer. Okay. Besides this, if you want to know about any particular judgment which you went through in the newspaper, you need to drop into the comments in this particular video. Let us know about that topic. We will come up separately with that video. Okay, chalo. So let's start this video. As you can see it on the screen, that these are the 10 topics which I have taken up for the month over here. So over here are the topics. So first topic, it's talk about, so I won't repeat all these topics because it's there on the slide. So I'll directly go to the slide. So the first topic is, it talks about the case that has to be an equal compensation for similarly located villages. So I'll just give you a brief. These are the two villages, majorly the Kukrola and the Fazalbaz. This is in the Gurgaon, Haryana region. Haryana mein Gurgaon, there is a district. Okay, that's a place. So over there, these are the two villages. These are adjacent. Now the question which came that, so there was a real estate company in this particular matter who wanted to build up the construction. So normally what they go to the villages, they ask the villagers, please give us this particular land, we're going to give you the compensation, and all the necessary government approvals are being done. Okay. So they went to the village, and now both the villages which are commonly adjacent, having the same area, both the facilities, nothing new was given, but the question came that one village was getting more compensation as compared to the other village. Now that is what was the matter which went to the court. So Kukrola and the Fazalbaz land acquired for the same project by a real estate company. So High Court gave more compensation to Fazalbaz, that is what I mentioned, despite Kukrola being closer to Delhi and the National Highway 8. So that was the matter which went to the court, and Supreme Court came with a judgment. So what was the question over here? That can adjacent lands be valued differently without solid reasoning? Now when they talk about the solid reasoning, is there any different path, a road, a project, a new flyover, or a reservoir or a river which is flowing from there, or the future prospects are different, then there could have been some another compensation to be given, but this was not the case right now. So does Article 14 require for equal compensation for similar potential also. So that is what was raised before the particular thing. So final verdict was Kukrola inner belt land to receive 1.21 crore per acre like the Fazalbas. This was the final decision given. And what was the concept which highlighted? That is Article 14, which talks about right to equality under the law. So everyone must have known about it. Now you see, there is a property concept related to a compensation between two villages. It can come in the form of this particular concept which you have already studied in a paragraph form. So that is how the topic becomes relatable for us. Next is section 4 of the notification. It says that the start of the land acquisition under the LAA, that is the Land Acquisition Act. So you can go, so whenever you see these things, so I have jotted down what is the legal concept, go read about it. And you can even search article on this topic. So that is how you build up that tree wala structure, where I said ki there is a topic we studied, there is a concept, and on that concept we will go and study about something. Okay? So this is the one thing. Okay? Second case is the caste certificate can't be disputed in the election petition. So there was already a petition which was lying in contrast with the election laws, and the question in that particular case came related to the caste certificate. So what was happened? Kerala High Court voided MLA A. Raja's election over the caste doubts which was filed against when he became the member of Legislative Assembly. So Supreme Court held that such certificates must be challenged under a separate law. You should not bring up into this particular case because it is related with some another law. Under separate law you can put up the question. So the question came, can eligibility under the SC status, that is the caste certificate status, be questioned during the election petition? That means election petition already filed था, उसमें caste से related बात आई, तो Supreme Court ने कहा caste से related matter should be dealt in some separate law. So the verdict is High Court judgment overturned, change हो गया, A. Raja's election restored. So he remained the Kerala's MLA, nothing happened. So section 100 of the Representation of the People's Act, grounds to void election, इस पे केस फाइल हुआ था, and that is why it raised a concern and Supreme Court came with the verdict और High Court का verdict हटा दिया गया. Okay, chalo, let's move to the third one, which is court can't stay bank guarantees without strong grounds. So it means that there was already a dispute, a contractual dispute was happening between the two companies. Okay? So contractual dispute means by buying and selling se related a dispute tha, where the concern related to Jindal Steel was there. Now Jindal Steel went to the bank. So there is already a dispute, a contractual dispute between Jindal Steel and one of the party was happening. Okay? So contract ka dispute ho gaya. Case was already under course. So Jindal Steel went to the bank कि भाई there was a bank guarantee which we got it. So can we encash that money? So already the question matter क्या आया कि dispute already चल रहा था. There was already a case going on. In that case they went to the bank to encash the money. High Court issued a temporary stay. Supreme Court reviewed legality. High Court ने stay लगा दिया कि नहीं, you can't go and go for the encashing of the guarantee. So the question is, can a court pause an unconditional bank guarantee? So there was no condition which the bank guarantee has given it. ठीक है? During arbitration, did the High Court misuse Article 227, which is the power of the High Court over here? Okay. So what's the final verdict? It says High Court order upheld as temporary safeguard, which happened. So High Court के order को क्या हुआ? That was upheld. Now what's the legal concept? Section 9 of the Arbitration Act allows interim relief. That means a contractual dispute under the arbitration provision was already filed. उसके दौरान ही इन्होंने जाके इनकैश करना चाहा, एंड दैट वाज दी, सो कोर्ट उस पे स्टे नहीं लगा सकता. आर्टिकल 227 इज द सुपरवाइजरी रोल, नॉट बाईपास रेगुलर अपील process. So it's a supervisory role जो हाई कोर्ट का है, which has been given under the constitution for the article 227. Okay, so I believe this is clear. Next we move towards the fourth point, which says the fourth case, that is NRI father gets fixed visitation rights. So what was the case? That between the father and the mother there was a case, a separation case going on related to the custody. The question came into the matter कि the daughter's custody will be with father या mother, मतलब मम्मी पापा में से किसके पास custody जाएगी. ठीक है? And since he was an NRI, I think he was in UAE रहते थे, so whenever he used to visit India, he always have to file applications with the court so that he can meet his own daughter. So that's why एक फिक्स्ड विजिटेशन राइट्स कोर्ट ने कहा भाई एवरी टाइम ही इज कमिंग, ही इज सैक्रिफाइसिंग हिज ओन टाइम, मनी, एवरीथिंग टू मीट हिज ओन डॉटर. ऐसा कुछ भी नहीं दैट डॉटर उसको बिलोंग नहीं करती, वो खुद ही उसकी बायोलॉजिकल चाइल्ड है. सो NRI father had to file 20 plus application in 9 months to meet his 6 years old daughter. So this was a question. Why every time I'm visiting and have to file the applications? So this was a question raised. So can repeated applications be forced for custody access? So this was the question. And next, should court prioritize emotional health of the child? So obviously the support with the mother is anytime needed, but meeting father also it's equally required for the emotional end. And because of this process of filing multiple applications whenever he is visiting, that is delaying the process. So is the reason if he would have been able to come 4 times in a month, he is not visiting and he is visiting only 2 times in a month, which is impacting the child's health. Mental health. So final word it came, prior court directions cancelled. Whatever court have given this direction, it is cancelled. And stable parenting rights given. Trial delays cannot block interim parenting. So trial delays means already there was a case between the couple जो pending था related to the custody. Now during that, why his rights have not been given to meet? So इसलिए ये delay नहीं होना चाहिए. So what is the legal concept? There are multiple legal concepts which are highlighted because in contrast with the family law also. So there is a Guardian and Watch Act which comes into the picture. This says that the child's welfare comes first in the custody decision. What is a visitation right? So this is a legal permission given to a parent, usually the one not living with the child, to meet or talk to the child. So ये एक legal permission है, visitation right. So this is a concept known to you. Now article 142, sorry, the special power of the Supreme Court to give complete justice even if the solution is not found in any law. So this is a add-on power which is been given with the Supreme Court, where nothing is given in any of the law. Supreme Court will come into the picture, take the matter into its own hands, the bona fide can be done easily, and then they could deliver the decision as per their convenience. But it will not going to bypass any of the existing law. That's why it's written not found in any law. Okay. Interim relief, it's a temporary order to protect someone's right during a particular case. So this is again a matter. And the last is the best interest principle, means if a rule being followed worldwide that says that the custody decisions must protect the child's emotional and physical needs. So these are the basic provisions which are highlighted over here. I would want all of you to just have a glance. Okay, chalo. Let's move towards the next one. It says, now this is something which I believe, besides having it important from the exam perspective, this is also important for the generic perspective also, that we should not do this thing. It says cut a tree, pay 25,000. So Supreme Court came up with this decision in one of the case which happened, which was like the trees were cut down near the vicinity of Taj Mahal, which is based out in Agra. So court cracked down on illegal tree cutting in the Taj trapezium zone. So there was a TTZ zone. Environment around Taj Mahal being harmed by unauthorized felling. So this is something which raised concern ki bhai, it is helping Taj Mahal to grow, because there were cases in the past also that there were some acid rains which were happening and the color of Taj Mahal was fading, and it became very difficult to conserve our own the historical heritage which we have. So what was the question? Can Supreme Court issue binding environmental penalties? Do they have the power to do so, which is binding on them? And can tree protection be enforced through judicial power? So is it some law or from the judicial power it comes into the picture? So the final word it came is Article 142, which we have already seen it in the previous one, used to make rules binding. Funds must be allocated by the state. So now the responsibility is upon the state, because it is coming under one of the directive principles of state policies also. So what are the legal concepts? So many legal concepts. What is TTZ? So it's a protected area over 10,000 square kilometer around Taj Mahal, created to reduce pollution and save the monument. So this is again Article 142 we have already discussed. Indian Forest Act, so again a new thing which comes to your knowledge now, that a law that regulates the use and the protection of forest and trees in the India. So I think while I'm recording this particular video, we already came up with related to a news that something the cutting of trees around 100 acre in Jaipur for development has also been taken place. So that is also raising concern, and there would be a lot of petitions will going to be filed against that. Central Powered Committee, CEC, a group appointed by the court to monitor the environmental cases. And what does PIL mean? So it's a case filed not for personal gain, but so that is what I said, that a lot of PILs, public interest litigation, is going to be filed in related to Jaipur case also. So that is what was there. Next we move towards the sixth case, that is a vague allegations are not enough in contrast with the dowry. So what happened over here is the Supreme Court acquitted man convicted under section 498A and the Dowry Act. So there was a case which was filed against a man, that is the husband, by the wife and the father of the wife, the father of the daughter. So majorly like the father-in-law and the wife filed a case against the husband. So in that matter, they brought up a case that there was once in their own lifetime that there was a miscarriage happened, and it was the reason that the husband was a bit cruel and everything happens, but there were no hospital records, no proof, nothing, no evidentiary things, but these were only the verbal allegations which were imposed onto the man. So allegations by wife lack detail, evidences and the medical proof which I just mentioned. And even a lot of time, besides the hospital records also of the miscarriage, there were no even the concrete proof about the cruelty of the allegations which she raised. So question, can conviction stand without specific acts or the proof? So the final verdict came, conviction was overturned, that was removed, and continuing case deemed abuse of law. Proof beyond reasonable doubt is an essential part which is there in the concept with the criminal law. Now you link how these concepts which you have studied is already there in our books, so that is how you can relate with these concepts. So what is the legal concept? 498A of IPC punishes husbands or in-laws for cruelty to a woman, physical or mental harassment linked to dowry or abuse. So this is again an important provision which have been in talks a lot of time in the society. But there is another law, that is section 4 of the Dowry Act. So I would recommend to go and read about these laws also. Whenever any faculty, any mentor, teacher says go and read about this act, just go and search objective of this section. The 10 points of that objective of this section will definitely help you to understand the base of these sections. Okay. Now if anyone asks for dowry directly or indirectly, they can be punished. So under the Dowry Act also, under the IPC laws also, it could be done, but the case was overturned and the man was acquitted. So that's why it is a vague allegation which was raised by wife against the husband. Next we have accessible of digital KYC mandated. Now this is in contrast with the people who are blind, who are disabled, who maybe someone is not having his hand, or the impressions on the arm or on the palm is not very clear. So that is what, because when we go to the banks or any KYC, know your customer thing happens, it's always take the recognition of a thumb impression, or they take their eyes impression being taken. So that's the matter happened. The petitioners with disabilities, while denied access to services like banking, pensions due to KYC systems requiring eye blinking or the facial recognition. Now this is a big question which happens because no one can predict it, and we talk about the equality in the country. So that's why the case was raised under the people who have been disabled. So there is violation of the rights, and lack of alternatives amounted to denial of access to essential public and private services like banking service. After the digitalization have happened in India, a lot of people wanting it, and no one choose to be blind, right? It happens because maybe some disease, or maybe because of some genes or something, it happens, or maybe lack of visibility, it happens. So that is why these recognition should not be there. They should have some offline presence also. Not everything 100% should be digitalized for these people. So all regulators, RBI, SEBI, IRD and any other equal body, SEBI and everyone, to enable thumbprint, voice based and offline options should be there. So definitely if someone who can't see, does not have a proper facial expression, there is some problem with the face, maybe like someone who is in the acid attack survivor, so it happens with them, but they can at least speak, they have this power. So the voice recognition can help. It's not only a strict thing that eye, face and thumb should only be there. Okay, a dedicated complaint redressal system must be created, which is a very great step which was taken. Now the legal concept comes about, as I already stated, that there was a violation of right. So article 21, right to life with dignity has to be there, equality has to be there, and right of persons with disability act was also highlighted. So you can go and read about about these legal concepts. Some must have already read about Article 21, but with the Person Disability Act, you can go for it. Next, we have the last three. Okay, so 8th is there. Name is a suicide note. Name in a suicide note, not enough to prove abatement. So abatement means someone would have pushed me, provoked me to do that particular thing. So there was a case which is coming over here that the husband died, so the case went to the wife and son, and he mentioned in his suicide note that they abated me, and because of them I have committed this suicide. So that is what they are saying, just mentioning of a person's name in a suicide note is a reason of the abatement or something else. So it says that wife and son named in a suicide note after a man with mental illness. Now this is something which is elevating the matter, that he had mental illness. It was not because of the couple, but it was already he had and died by suicide. He had history of schizophrenia, depression and OCDs. Now someone who's already suffering with this, nothing offensive, but yes, if they commit certain things, their mental condition needs to be taken up. So that's why a lot of therapists, and by giving the therapies, talking to the counselors, psychologists, it clearly come to the conclusion, and the reports also clearly states that if someone is in this mental condition, it might create problem with them. So people need to deal with them properly, carefully, with empathy, but still it's a matter when certain happens, only a name would not be sufficing the need. Is naming mentioned in the suicide note enough to prove the abatement? So there is an anticipatory bail which was granted with no custodial integrations. That means they won't be keep on asking again and again to come and give the under the interrogation. And the court stressed liberty cannot be denied on emotional allegations alone. So yes, we are emotionally connected with a particular matter with someone obviously died by suicide, but it cannot be denied on the emotional allegations alone. So that's why court stress about the liberty part. Next, section 306, abatement of suicide. A lot of people must have studied it while doing the criminal law. Last two, the one 15-day split custody order, a new thing which the High Court came up, the Supreme Court came up with a judgment. So what already happened, that Kerala High Court have ordered an alternating 15-day custody between the parents. That means 15-day mother ke saath, 15-day father ke saath. That is what the 15-day split. Mother challenged it due to the emotional harm and lack of the proper care. So there was a question that mother came to a point that the father, whenever he takes, so it's a matter about two children. So I think the daughter was age 9 years and the son was maybe around 2 to 3 years only. So the court clearly mentioned that whenever the daughter was going to the father's place between these 15 days, so there was no proper support, no talking at home, father coming late at home, the food have always been ordered online, and no hygiene facility was there at the home. This is what it's impacting the mental capacity of a child of age 8 to 9 years. But for a 2 to 3 years, that maybe the father's support is definitely needed, but during that it's a developing age, so a mother's support is majorly more needed. That is what the matter over here. So does alternating time ensure fair parenting, or it's harming the child's development? That is what I told you, like not the hygiene part, not the mental capacity over there. Why? Because the father was not able to spend more time, and mother was already in working with an IT firm, IT company, where she was having work from home. So that's why it was clearly came ki split custody should not be there. So can custody be split without looking at the emotional readiness? So that's why they took into account the emotional and the mental capacity of the child, because it's in the development stage. So full custody granted to the mother because she will be the one who can able to take custody, and father given alternate weekend visits and supervise access to the younger child. So this is what I mentioned, the younger child, the son was of a lesser age, the elder one. Okay, so legal concept is best interest of child, emotional, physical, social growth is being prioritized. This was the base become for the final decision. This is the concept which you can study. And permanent custody under the Guardians and Watch Act. So this is Guardians and Watch Act are already been in talk with this. Okay, chalo. The last part, and then we'll come up with the end of the session. So earnest money not refundable if buyer defaults. So what is earnest money? It says that security for contract performance. Now if you go and plan to buy a particular flat or a land or anything, there is a contract. They might end up that this is the advance which I am giving to you, and the remaining money I am going to give it to you. That advance which you give, because now you are going to perform your obligation, is the earnest money. So now the person says that the remaining performance or the remaining money I will not be able to give it, and the earnest money will not be refunded because that was an explicit clause written in the contract. So that is what the case was about. So buyer failed to pay balance amount in a property deal. Seller invoked the forfeiture clause. So seller means the one who was selling the land. He was given an advance by the buyer and he retained 20 lakhs paid in advance. So when a person who's buying the land, if you are buying a land, you have paid 20 lakh in advance, that means you hold a right over the property and you want to buy it. Now why you are denying the performance? That was the question brought. So was the forfeiture a penal action or a valid enforcement of the contract? That means will it attract penalty? या ये जो forfeiture वाला clause which was there, that if you don't perform the contract, I will going to forfeit this particular term and will keep the money. ये explicitly contract में it was written, then it is easy to go for it. So did the buyer explicitly pleaded for a refund in the court? This is also a question which was raised because buyer didn't even ask explicitly for the refund of the money, but the case was lodged. So buyer's refund plea rejected due to lack of specific pleading under the section 22 specific relief act. That means even though he brought a case, but the way he was demanding the relief under this act, it was not allowed. The court understood that there is something fishy and it should not be given in his favor, and forfeiture upheld as valid, that the seller invoked the forfeiture clause is fine. So the legal concept earnest money over here, and the next one is section 22 subsection 2 of the specific relief act requires explicit request for refund. You need to make a request in your in the case and the application which you brought before the court. That is what needs to be done, and I believe that all the students must have watched this video till the end. And if you want to know more about any of the topics, anything which you believe ki sir this is something which I am struggling with the concept or any other thing, please let us know in the comment section. And if I get more than 20 comments in this video about that we are liking this series, so we will come up with more such videos. And guys, don't forget to check out our monthly current affairs roundup also, which is there on our YouTube channel. Check the playlist properly, the link is also given in the description. Till then, Siddhant sir is signing off. Jaldi wapas mulaqat hogi. Bye bye, take care.